Okay, welcome to Constitution Day 2019. I think I've lost count of the number of Constitution Days we've had here at NMSU-A, but they will continue. So thank you all for coming. We're going to get started while people are still getting tacos, so please help yourself to tacos. There's no worries there, and hopefully they'll hold out, so we'll have enough tacos. Whoops. Okay, so I want to first thank everyone who helped to make this event possible. First, the Teaching and Learning Committee here at NMSU Alamogordo sponsored the delicious tacos that you're enjoying, so yay, that's one of our faculty committees. Also, President Van Winkle, who's always very supportive of this event, Jasmine Martin, who provides us with sound and vision, Rick Comer and the facility staff who got all this set up for us, and Chef David, who has prepared the tacos for you. So thank you to everyone who helps out, and probably people I didn't mention as well. So today's Constitution Day event will be a panel discussion, not a debate. I heard someone say, oh, it's going to be a debate. No, not a debate. On the constitutional limits on mental health red flag laws. So this is not a debate on gun control. This is about a very specific type of legislation that is now being considered in many states and also maybe by the Congress. The constitutional issues we will discuss in relation to the red flag laws are the Second Amendment, due process, and equal protection. Now I'd like to introduce our panel. Did I say my name? No. I'm Kim Lopez Gallagher, sorry. I'm a professor of government, U.S. history, and philosophy. To my right here is David Overstreet. He is professor of criminal justice and paralegal studies. To his right is Matthew Wade, and Matthew is, let me make sure I get this right, he is a domestic hearing officer and also an adjunct professor here at NMSU-A in criminal justice, is that correct? Yeah. And to my left is 12th Judicial District Judge Daniel Bryant. We're very happy that Judge Bryant has agreed and has time to join us today. And to his left is Rebecca Scott Courvoisier. She is a civil rights attorney. So that is our panel, and thank you all for coming to our campus. Yeah. This is really a great panel. Lots of expertise here. Okay, so I'm going to start our panel discussion off with just an overview. Everyone hear me? Okay, of gun deaths and mental illness in the United States. So first of all, I'm an academic, so I'm going to cite my sources. The following information I retrieved from the Pew Research Center. So in talking about the number of gun-related deaths, in 2017, in the United States, 39,773 people died from gun-related injuries, and this is according to the CDC, the Centers for Disease Control. This includes gun murders and suicides, as well as other less common gun-related deaths that are tracked by the CDC. Suicides account for 6 in 10 gun deaths, according to the CDC. The 39,000 plus gun deaths in 2017 were the most since at least 1968, which is when the CDC started recording this data. Over time, there were 12 gun deaths per 100,000 people, the highest in 2 decades. But this is still below the 16.3 gun deaths per 100,000 people, which happened in 1974, which was the highest rate in the CDC database. Okay, now I want to talk a little bit about mass shootings. So according to the Gun Violence Archive, 4 or more people are shot or killed in a mass shooting, or that defines a mass shooting, sorry. So in 2018, 373 people died in mass shooting incidents. This is a small fraction of all gun murders that occur nationwide every year. The FBI has found an increase in active shooter incidents between 2000 and 2013. So now I want to talk a little bit about mental illness. Okay, so first of all, mental illness mental illnesses are common in the United States. Nearly 1 in 5 adults live with mental illness in the U.S., and that's 46.6 million people in 2017. The proportion of overall risk of violence attributable to mental disorders is small. And one thing I found when I was doing this research is that the connection of gun deaths to mental illness is murky at best. It's really hard to find a causal connection there. The U.S. data put the population attributable risk percentage for violence due to mental disorder between 3 and 5%. So in other words, that's the percentage, the chances of the risk of gun violence due to mental disorder. Okay, this is the last thing I'll say, then I'm going to turn it over. If the proportion of violence accounted for by mental disorders could be eliminated entirely, which is unlikely, 90 to 97% of violent behavior would still remain. So that particular fact was cited in about 4 different articles that I read, so it's very interesting. So now, with that, we have an overview. I'm going to turn this over to you next, to David.
All right, thank you, Kim. And before we forget, there's a student sign-in sheet in the back, so please sign in so that we know that you're here and how many folks participated. So the Second Amendment is just one of the constitutional issues that a red flag law could address. It may get the most Twitter mentions, but it's only one of them. So first, we should probably start with, what does the Second Amendment say? A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So first, there's 2 clauses. The first is that prefatory clause about the regulated militia. In 2008 Supreme Court case, D.C. versus Heller, which is one of the few cases that talked about it, the court basically said that we can look at those 2 clauses separately. The historical context of what they meant by a well-regulated militia, we could have a whole deep dive on that. But I want to read from the opinion where they said basically we can separate those 2 clauses. And the opinion was written by Justice Scalia. It was a 5-4 decision striking down a gun control piece of legislation. It said it may be true that no amount of small arms could be useful against modern-day bombers and tanks. But the fact that modern-day developments have limited the degree of fit between the prefatory clause, that's the one about the militia, and the protected right cannot change our interpretation of the right. So essentially, if we're looking at the Second Amendment, we really just need to focus on the right of the people to keep and bear arms shall not be infringed. All right, and that seems simple enough, but one of the reasons why people don't like lawyers is I'm going to tell you that's not what it means. There's no right in the Bill of Rights that's unlimited. Every right has a limit. The First Amendment says Congress shall make no law respecting or shall make no law abridging. And there are a host of restrictions on speech and religion and freedom of exercise. Search and seizure, shall not be violated unless one of the 10 exceptions apply. So when I say that, the starting point of the analysis is the text, it's not just the starting point of analysis of that text. It also says the diversity jurisdiction for a federal question is $20. It's really $75,000. All right, so if a law is going to address or raise a Second Amendment right, the courts, when they look at it, and this is not a constitutional law class, it's a panel discussion, basically they look at a couple things. What is the nature of the right that's being infringed? What is the government interest that's being protected? And then how well is the law crafted to protect that interest while minimizing the infringement of that right? And so what Professor Gallagher is giving you is those stats. That's going to be that government interest that's going to motivate those legislatures. That Heller case from 2008 basically has 2 key holdings that are important for our discussion today. One is the Second Amendment right is not just a collective, well, you can have a gun if you join the militia, otherwise you can't. The Supreme Court clearly said it's an individual's right to keep and bear arms to protect themselves, their home, and their security. The other thing it said is that the historical prohibitions still apply. So yes, there is this right for an individual to keep and bear arms, but we're not going to invalidate the historical restrictions. And the first one it listed is the prohibition against possession of firearms by felons and the mentally ill. Now, as Professor Gallagher points out, that may not be a super enlightened view of mental illness, but that's what the case says. So there's going to be, sort of a red flag on the constitutional analysis of that, because the first thing they're going to do is, well, restricting firearms against the mentally ill, isn't that what Justice Scalia said was a historically recognized restriction? And the answer to that is going to be yes. Is that the district court law that was at issue banned all handguns in a home. And the Supreme Court talked about how the home was going to be the most sacred place. If an individual's right to keep and bear arms to defend themselves was going to have value and its significance, the home is probably the most important place for that to happen. So I think that's going to be a pretty compelling issue when you're looking at the Second Amendment debate on a red flag law. There are no other Supreme Court cases. If you guys want to calendar this, December 2nd of this year, the Supreme Court's going to do oral argument on a New York City ordinance that I think will be super interesting. And they will force the court to kind of flesh out some of these issues that it really hasn't. Several circuit court cases have held. Recently, this year, there's two that have come out upholding bans on assault weapons and high-capacity magazines based on some of the interest that Professor Gallagher was talking about. But again, that's not the red flag issue. There are two state court decisions that have addressed red flag laws. They upheld both red flag laws relating to mental illness, and they both upheld them on what for some may be a troubling ground, and that is that they said that these laws target the mentally ill, so it does not in any way impact the right of law-abiding responsible citizens to carry a firearm. Because by definition, under that analysis, if you have a mental illness, you're not a law-abiding responsible citizen. That's troubling in a lot of circles, but that's language that can be traced back to the Supreme Court decision. So I think the constitutional analysis, those will be the issues they're looking at when they're looking at it from a Second Amendment perspective.
Becky Cavassier now.
So Mr. Overstreet was kind of giving you an overview on Second Amendment law. These things come up in different contexts and different circumstances when we're talking about the way that people challenge the constitutionality of a provision. And here we're talking about red flag laws, where different states, different municipalities, cities have different versions of what they're proposing to put into place. And I'm not entirely familiar with all of the different versions, but in each respect, there's some sort of law or statute in place that gives either an individual or a state entity the authority to flag somebody who may be dangerous, or who may have guns, who have them in their house, whether it's because of mental illness or a domestic violence issue, and allow the state as an actor or an agency to come in and remove those weapons from somebody's home. So when we're talking about a Second Amendment challenge, that's likely to come up in the future because there's not a lot of case law yet. These are new issues. But it's likely to come up in the context where, say, someone is in that circumstance themselves. They've been flagged and there's some kind of an order in place that allowed somebody to come in and take their weapons, and now they find themselves in a position of trying to get them back or to challenge the legality of what has happened to them. So that's sort of a facial challenge, and when we think about due process and equal protection, which is what I'm talking about, those come up in a little bit different circumstances some of the time. And those can be used as another way around to challenge the constitutionality of a statute in a circumstance that may be outside of a criminal proceeding or a forfeiture proceeding, where somebody is bringing a civil action under the federal civil rights statutes that allow people to do that, to challenge the constitutionality of a specific provision. So due process is an argument that really stems on whether or not somebody was provided a fair hearing. It doesn't prohibit the government from doing something, from taking a particular action. The question is whether government in that circumstance has afforded a person the process that is due. And what is that? That's usually the right to a hearing in advance before they are deprived of life, liberty, or property, and in front of an impartial tribunal in which they have the opportunity to present evidence. And that is one of the circumstances that creates, is a matter of contention for people in this circumstance, is that we're talking about somebody's guns being removed from their homes based upon pure allegations in some circumstances, as opposed to where a person has been convicted of a crime and then you are sentenced to serve a particular sentence. You've had your right to meet the judge and to give your evidence, but this forfeiture can happen in advance. And so sometimes those sorts of procedures can run afoul of the due process clause, to the extent that a person is not then afforded a right after the fact to challenge that action. Another circumstance that can come up and that is disputed in the constitutional context is when we're talking about somebody making an allegation that somebody is either dangerous or in some circumstances the burden to prove their sanity or the fact that they're not dangerous may be upon that person as opposed to the converse. And so I guess we can all imagine ourselves in that circumstance having to prove we are safe. And how would you go about doing that? How would you go about proving that you are not dangerous in a circumstance where you've just yelled at somebody who cut you off in traffic or something like that? All of a sudden these little things that you may not think about in your life speak to your inability to be deprived of what is to many people a fundamental right that they feel that they have as an American. And you are then in a position of having to prove that you are entitled to the right. Generally that goes the other way. When we are talking about civil rights, they belong to everybody, and before a person is deprived of them, the government has to come in and prove that there's a sound reason to do that. And then in the equal protection context, that's another sort of area where these types of statutes could face a challenge. It's a little bit trickier in that circumstance because what the Equal Protection Clause says, it's in the 14th Amendment, is that everybody is entitled to the equal protection of the laws. And then the case law says that when people are similarly situated, they have to be afforded the same rights and benefits of all other people who are similarly situated. And just thinking about that, you can see, well, there's a lot of room for error there and a lot of discretion that might apply in that kind of a circumstance. Are all mentally people who may have a mental illness or a mental condition similarly situated? Are they all equally dangerous? And we may have some psychology majors in here who are leafing through the DSM, and you know there are varying degrees of mental illnesses and things, challenges that people face, and they're not always necessarily correlated with somebody being dangerous, or certainly to have some level of an impairment that would result in their the legality of them being deprived of any civil right, whether it's a right to vote, a right to a gun, any of those kinds of things. So in that circumstance, equal protection would also in that case be a hard challenge to make for the reason that a person's rights are always balanced against the rights of the state. Sure, you may have a right to do a particular thing, or you may have an entitlement to a particular benefit. However, if the state's rights overweigh your rights, then your right can be curtailed in some particular respect. So if any of you want to follow along, I have some constitutions. And I know when I was in college, I had one, I kept it in my backpack. I still own it. It's 30 years ago. But if you want those, they're here.
Great, thank you, Ms. Cavassier. Next, we have Mr. Wade, who will talk about how mental health red flag laws could be structured to meet challenges.
So, also I kind of wanted to give a little bit of an overview of what is this red flag law, and so just kind of lay a little bit of a basis for it too. In 2008, at the tail end of the Bush administration, the Supreme Court, and authored by Justice Scalia, had stated in that case that Professor Overstreet was talking about earlier, that, and I'm quoting here, the right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose, it's not, the Second Amendment is not an unlimited right, is what he was saying there. And he said they offered later in that opinion some ways in which to affect that and still to get to those government interests. And one of those that they suggested is to pass an extreme risk protective order law, an ERPO. And those ERPOs are what are also known as red flags. You see a red flag, if there's an extreme risk, then there should be a protective order. So protective orders are common in law anyways, injunctions. It's something where somebody acts now, so that way we can make a protection right now, and then we get to the court as quickly as we can, so that way we can sort it out. But because there's such an extreme risk to safety or whatever, we're going to act before the court has something to say. So a year and a half ago, March 2018, President Trump in a statement said that ERPOs should be carefully tailored to ensure the due process rights of law-abiding citizens that are protected. As Becky was saying earlier, that we still have to be conscious of those due process rights, but he was, at that time, a year and a half ago, already talking about ERPOs. About a year later, Senator Lindsey Graham was saying that right now, on the national level, and this was March of 2019, right now on the national level, that's probably something that the market couldn't bear, is the way that he said it. But he said, creating an incentive at the federal level for states who want to go down that road, in other words, giving grants to states in order to work on this, he says, I think that's the best way, at least initially, to solve this problem. And then finally, I think we're all, well, we finally, after the shootings in El Paso and Ohio earlier this year, President Trump said, we must make sure that those judged to pose a grave risk to public safety do not have access to firearms, and that if they do, those firearms can be taken through rapid due process. So still, there's that due process. So how do we get there? And I think that the best way to think about how do we get there, or how do those laws get structured? I'm not trying to advocate one way or another, just trying to educate. The place to start is, what do we have in place right now? So right now, the state is already under an obligation, the courts are already under an obligation to inform the federal government about certain factors. And so we have what's a passive system. And many of you probably are just anecdotally aware that if you're convicted of a felony, then you shouldn't have firearms. So in New Mexico, the law is that it's unlawful for the following persons to receive, transport, or possess a firearm: a felon, a person subject to an order of protection under the Family Violence Protection Law, and that's a new one that was just put into place this last year, and a person convicted of any of the following crimes: battery against a household member, criminal damage to the property of a household member, stalking, or a crime listed under the federal misdemeanor crimes of domestic violence. So there's also a layer that has to do with the mental illness, which is what we're here talking about, right? And the mental illness rules state that when a person has some sort of order issued against them, that the state needs to give them notice. You are no longer allowed to have firearms, and then the courts, it's their duty to send that information to the feds, so that way when somebody tries to buy a firearm and a background check is done and they can see that this order's been entered. So the people who are not supposed to have it for mental illness issues, and this is Rule 1-131 of New Mexico Rules Annotated, just in case anyone's keeping track. We are recording it. So, orders that require notice. If you are subject to an order for plenary or full guardianship or plenary or full conservatorship and you're totally incapacitated, so that means either, most of the time it's end of life type of situations, but it could also just be mental defectiveness to where you're totally incapacitated and somebody has started taking care of you, either your money or your entire person. Then, if that's the case, if you're in that situation, then they're supposed to get notice. You're no longer allowed to have firearms. And then finally, also an order of commitment under the state statutes 43-1-11, 12, and 13. So what those are if, take one step back to 43-1-10, if a officer arrives on scene to a place where somebody just tried to commit suicide, then they can do an emergency mental health emergency hold, and so they can take that person and take them directly to a mental health either facility or whatever, and then there's a bunch of due process that comes after that. You have to have a hearing within 5 days. You have to have a petition filed within 5 days if it's going to be more than that short hold. The other way that emergency can happen is if a doctor says that because of a mental illness, this person needs to be held right away. And so those are the emergency ones. That's Section 10. That's not subject to this federal firearm restriction. But after that initial hold, that initial emergency, we're going to take you to the hospital, then they have the right to a hearing. And if you get found at that hearing to have a mental disorder, if you get found at that hearing to have a mental disorder, and because of the mental disorder, you present a likelihood of serious harm to yourself or to others, and that you would benefit from treatment, and that the commitment that is going to happen, sending you to the hospital, is the least restrictive means, then you can be extended and sent to a mental hospital for another 30 days. At that point, and then the subsequent orders after that, that's when you've lost your right to a firearm. So then, the other two ways is an involuntary protective services or protective placement. That's when adult protective services, and this is also another one of those end of life, usually is when you see it, situations, or just an adult who's another mental illness thing. If you have an order where a judge finds by clear and convincing evidence that adult protective services needs to take you into custody, then that's another way to forfeit the firearms. And then finally, an order subject to assisted outpatient treatment, and that's if you have demonstrated a history or lack of compliance with treatment for a mental disorder in the past that's resulted in serious violent behavior towards yourself or towards others. If a judge finds that you have, by clear and convincing evidence that that's the case, then you have that notice and order that you're no longer allowed to purchase, own, or possess firearms. So this is all a very passive system. The red flags, the ERPOs, are looking to bridge that gap between the passive system where they just say you are not allowed to have firearms, to instead where they go and take your firearms if you have these red flags or this emergency risk situation, and then instead of just saying you're not allowed to have them, then there's actually going to be a government agent or whatever going and retrieving them from you until you have that due process situation. So this actually came up with in Albuquerque cause, there's an article that we were all passing around, getting familiar with this, and they had to continuously detain the person under that 5-day hold until they were able to get through everything else to get the firearms away from them. So it's the red flag, the ERPOs that President Trump was talking about was to make sure that those firearms are out of the loop from the beginning and still have that rapid due process on the back end. So one way of bridging that gap is the simple in that first thing that I read you, the list of people who are it's a crime for them to have firearms, where it's the felon and people who are subject to a restraining order for their domestic violence, would be simply to just say and those subject to any of those other orders, and then it would make then that a crime, and so an officer who sees a crime committed in their presence can investigate it. So the other difference between a red flag law in most cases and in most states that have passed them so far and what we have now is a medical doctor or a physician that's approved by the courts. If the medical doctor is not available, it has to be that person who says because of a mental illness they're likely to cause harm. The red flag laws that are being proposed in many places, it can also be a family member, somebody who lives with them, or a police officer who's investigating. Right now, it's only doctors that get you to that place, and so that may be one of those things that's causing that rapid due process to shrink, is that we have to have a doctor come into the situation, interview people, and go through. But it also goes back to what we were saying earlier about is having somebody who lives with you just signing an affidavit that says, yeah, he said that he was going to shoot up the bank. That trust factor, is that a high enough burden for the government to act and infringe upon your rights? So the long and short of it really is that in making a red flag law, it would either criminalize those mental health owners of guns, like Becky was talking about, and or it would be saying that all people who have some sort of mental illness then fit into another category, as Professor Overstreet was talking about. So it's a sticky wicket, but that's that's
a fair summary.
Yeah, that's what red flag laws would be like.
9 minutes for questions.
Yeah.
Rachel.
Okay, thank you, and thank you, panelists. Okay, Judge Bryant would like to weigh in.
I'm just going to take a couple of minutes because when Judge Snyder asked me to come and fill in today, one of the first things that came to my mind was, why are we talking about red flag laws? Why has that subject come up? We've always had mental illness in our country. We've always had a mental health system. We have one now. We had a different one in the past. We've always had firearms. I was 12 or 13 when I got my first firearm. It was a single shot 22. Okay? Back in those days, the real fancy guns had a magazine that would hold 5. Okay? So things are really different today on both ends of this spectrum than they were as we all grew up. I'm 67 years old, so I've had a lot of time to look at all of this. So why are we talking about red flag laws? We have a system, there is due process. Mr. Wade is exactly correct. The way it is set up now, the process must occur ahead of time, okay? And when you start looking at red flag laws, what they're going to do is they're going to try to address this, and I'm going to describe it as a perceived gap, because we don't know whether it's a gap or not. And this is why. The El Paso shooter, he was on the federal list, no firearms. He went and he tried to buy a firearm, and he popped up on the list, and the dealer said no, and he wasn't able to get a firearm. Case over, done, system worked. Well, but a few weeks later, something really awful happened right down the road here in El Paso. And that person went to a private person, obtained a firearm, and then the El Paso event happened. So now when we're talking about why are we talking about red flag laws, what is a red flag law going to do in that environment? Okay, and I'm not expressing an opinion, I'm laying that topic out there for you to think about. Under the current system, if somebody is an immediate threat to themselves or others, then right now the system says we take hold and process happens after. That was that 5-day hearing Mr. Wade was talking about. So there is an immediate system that's in place. Mr. Wade talked about here in New Mexico, the physician must be involved and or a police officer must be involved in order to start that immediate system. Right now, family members are not permitted to do that. So is a red flag law going to address that and change it? Okay, perhaps it will and perhaps it won't. A couple or 3 days ago, I went on and looked because I wanted to know 17 states out of 50 have passed red flag laws. There are red flag laws pending in a number of jurisdictions right now, and unless something happened in the last 72 hours or so where somebody passed one, we know that 17 states have already passed them. None of them are the same. Each one is different. Each one has different steps, different protections, different triggers. And so when we engage this conversation here in New Mexico, and this is what I'm going to wrap up with, I want you to remember there are two pieces to this. There's really two conversations. One conversation is a political conversation. That is the conversation that is engaged, and then it results in somebody drafting a bill. That bill gets submitted into a committee at the legislature, and it goes through the process. It gets tinkered with, and it gets passed. That is a political conversation about red flag laws and this perceived gap. There is a legal conversation about red flag laws and this perceived gap. And the panelists here have outlined some of the elements that are in that legal conversation. They are distinctly different conversations with distinctly different results because the arena is different. The whole application of what we're doing in that environment is different. A legal conversation is way different than the political conversation. As an example, and just to lay this in sharp contrast, have women always been able to vote in this country? No, we all know that's not true. Wasn't there at time laws all over the country that disallowed women from voting? That was the result of the political conversations that were occurring at those times and those places. At the end of the legal conversation that occurred on that topic, women were given the right to vote. And there are a host of other topics in our history. The mental health system in the United States was unraveled beginning in the mid-1970s through the mid to late 1980s. It was completely unraveled. Systems that had been in place for generations were shut down and closed. Right here in New Mexico, 8, 10, 12 facilities all over the state were closed. When that conversation was happening, all of the issues surrounding what is a mental illness, who is mentally ill, when is somebody mentally ill and they need assistance, when is somebody mentally ill and they're dangerous, all of those conversations were happening, and there was a robust conversation at that time about putting in place a replacement system. The problem was we never built the replacement system, not just here in New Mexico, but not anywhere in this country. And so today, now we get to talk about red flag laws because we've come right back around full circle. We're inadequately dealing with mental health issues in our country. If Professor Gallagher is right and 1 in 5 has a mental illness, 1, 2, 3, 4, 5, you shouldn't be listening to one of us. Okay? If there are 200 million Americans, 40 million of them have a mental illness. If there are 2 million New Mexicans, 40,000 of them have a mental illness. We're not talking about a small subject. We're not talking about an uncomplicated topic. We're talking about a subject that we have to be truly thoughtful and careful, and we have to be willing to examine and look and make sure that we're making thoughtful decisions about what is the right path forward.
Thank you, Judge Bryant. We have 1 minute until 1 o'clock. Is there maybe 1 or 2 questions? I have a class that starts at 1, but I told my students, see, there's a few students. Okay, cool, they're here. So we're good. Yeah. Oh, students, please sign in. There's some salmon-colored, orangey-colored sheets back there. Are there any questions for any of our panelists?
I have a question. Listening especially to the judge, it sounds very much like what we're building, let's say that all the red flag laws get passed, if we're looking very far forward in the future. Are we just teaching the people who are mentally ill or who are just determined to get a gun, that they have to find a different route to get their gun? Won't we just create a system whereby instead of selling opioids, now the bad guys will sell guns on the street to people who can't get one legally?
I'll jump right in and answer that, and the answer is perhaps we are. That's part of what we really need to think about. It's easy to get excited and angry and passionate and close your fist and raise it and shout and cut off conversation when you're talking about a subject like this. I promise you, if we do that, we're making a tragic mistake because of things just exactly like that.
Thank you. Maybe one, yes. Could you?
I'm sure everybody at this table has an opinion about that. And I think that the answer universally, or at least certainly pretty robustly in the room, would be certainly not. We should be listening to everyone.
Okay, well, I think probably in the interest of time in my class, will. And I'd like to thank our panelists, Matthew Wade, David Overstreet, Judge Bryant, Rebecca Scott Courvoisier for joining us today. And I learned a lot. I hope you did too. And I hope one takeaway you'll have is that this is not a simple subject. There are no simple answers. And I think it's going to take more conversation like this where everyone is reasoned and is thinking objectively and willing to look at opinions other than their own and the facts most of all. So thank you everyone for coming. Really appreciate it. And there are constitutions up in the front. Please help yourself to a free constitution. Thank you so much.